Rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. You may be seated. Welcome to the First District Court of Appeal. We have one case on the docket today. It is Florida Department of Health versus Smith et al. Counsel for the petitioners, you may proceed when you're ready.
May it please the court. My name is Rick Figlio here on behalf of the Florida Department of Health. With me at council table is my law partner, Allie Aker, and I'd like to reserve 5 minutes for rebuttal.
So noted.
It is a well-settled principle of Florida law that a plaintiff that wants to challenge an agency rule or wants to challenge an agency's application of a rule in a specific set of circumstances must first exhaust any adequate and available administrative remedies before raising any of those issues in a circuit court proceeding. With respect to the central issue in this proceeding, the department's determination of when to release confidential and exempt data related to a disease of public health significance, how much of that confidential and exempt data to release when a public health necessity requires it, and who to release it to. The department's determination is governed by a statute and a rule implementing the statute. The plaintiff's construction of that statute is textually indefensible. The statute on its face plainly and unambiguously states that all of this disease data at issue is confidential and all of it is exempt from inspection under Chapter 119.
What does this arise in this kind of a context as opposed to, it seems that you're making jurisdictional type arguments that ultimately goes to whether this can even be decided by a court, subject matter jurisdiction. And so why doesn't this arise in a motion to dismiss or summary judgment conduct? Why is this coming to us with a back and forth over making a corporate rep available for a deposition?
It's a good question. We don't view this as a jurisdictional argument. We think this court's precedent establishes that it's not jurisdictional, that the administrative exhaustion requirement is a prudential requirement that seems to be pretty universally followed.
Well, I guess you bring up separation of powers, which
sure
sort of goes to, okay, can we do anything?
Sure.
Yeah.
Yeah, which also is probably prudential. That doesn't mean that in this context it ought not be followed. But we don't view this as a jurisdictional thing. We did move to dismiss. We acknowledge that there are cases out there that say if a trial court denies a motion to dismiss, that the denial of a motion to dismiss in itself does not necessarily constitute the sort of irreparable harm that gets you certiorari relief. However, there are plenty of cases from this court and from the Supreme Court that talk about the context of an overbroad, burdensome, irrelevant deposition or other form of discovery that has nothing to do with the case. And our view of this case is, by virtue of the fact that there's this exhaustion requirement, which your case, the Florida Society of Newspaper Editors case, establishes as equally relevant in the context of public records, this discovery that they're seeking is just not appropriate for this court, that it should be, the sort of thing that should be pursued in an administrative forum by petition and not in a circuit court.
So the irreparable harm here, the jurisdictional question that we have to analyze, it goes to the burdensome nature of having to make somebody available and prepare a corporate rep for deposition.
I think so. It's a matter of extreme to just, I don't want to minimize the burden, but yes, I think your cases and the Supreme Court cases establish that just having like a relevance objection in and of itself is not enough. The issue is there a whole line of questioning? Is there a ton of discovery coming your way that it reaches the level of, which is consistent with the rule, right? Rule 1.280, where all this originates from. The plaintiffs are authorized to only seek discovery on what's relevant. However, the rule says that you can't object merely on the basis of relevance. You have to an objection on the basis, if you want a protective order, that the discovery reaches the level of undue burdensome, it's an undue burden, it's overbroad, it's designed to embarrass or harass. And your cases and the Supreme Court's cases seem to kind of acknowledge that and transfer it to this context. So in this situation, our position was that we were willing to go down this stance and subject a witness to this deposition when we didn't realize that this was really the whole case for them. We thought it might be a few questions or a small line of questioning. We didn't realize that this was what it was all about. This whole case was going to be an exposition on the Surgeon General and the Department of Health's determination of what constituted a public health necessity. And in our minds, that put it out of the context of merely just an ordinary relevance objection to a few questions, to this burdensome, the whole case is kind of an irrelevant kabuki dance, which ultimately, hopefully, would be corrected on appeal.
But that is also the demarcation between a document that becomes public and not, right? As I read the statute, all this information is exempt and confidential, except this exempt and confidential information can be released under this necessity to public health.
Right.
So that's what demarcates that which is public and that which isn't.
So, yeah, Your Honor, I'm not sure I understand the question
I
there.
guess my response to what you're saying is that that is the issue. And when they file their complaint seeking these documents, what they're saying is this is necessary for public health, and that's what takes this out of the exemption, so that has always been core to, from the outset. That is the question.
Sure, but I think the one thing I'd clarify is it all is in the exemption. I mean, there's no way to read the statute otherwise. All of this material is confidential and exempt. So the only question is whether, frankly, we could move to dismiss. I mean, the circumstances were happening so fast. I think at the time, these public records cases happen so quickly. I'm not sure we appreciated our argument on the outset that this probably ought not be a public records proceeding at all by virtue of how the statute reads, right? That any right that the plaintiffs might have to these documents are in 381.0031 sub 6 and not under 119 by virtue of their confidential and exempt status.
Let me ask you about the respondent's argument on burden shifting. So we know that in a Chapter 119 proceeding, the agency has the burden to demonstrate that an exemption applies. And so if I understand it correctly, one of the respondent's arguments is that by construing this as a rule challenge, you're flipping the burden so that the requestor basically has to disprove the public health necessity. So could you answer that specific argument?
Sure. I'll answer it a few different ways. I mean, the first part is that under the text of the statute, this information is confidential and exempt as a matter of law. You don't need a court proceeding and a judge weighing in on that. It is confidential and exempt, period. Part two, even if that wasn't the case, the Florida Society of Newspaper Editors case establishes that public record, if that was a problem now, it was a problem when this court's precedent was decided in that case. The other thing is, if you think about how the statute is intended to work, from a practical standpoint, applying it as written as opposed to how the plaintiffs are suggesting it be written is the only thing that makes practical sense. The Surgeon General and the Department of Health are subject matter experts in the matter of public health as designated by the legislature. And so the circumstance here is all of this information is intended to be confidential and exempt by operation of law and only to be released when necessary to public health. So who should be making that determination, right? So the determination either should be made by the designated, legislatively created public health expert or by a court with the determination made by the public health expert being presumptively wrong.
Well, so if we look at the Constitution and the grant to public access to documents, it's pretty broad, right? And it authorizes only the legislature to make these exemptions. So where in the text of that provision does it allow any administrative rulemaking or involvement to carry out an exemption?
Okay, well, first of all, so reading the text of that provision, it says all of this information is confidential and all of this information is exempt.
Right, but the determination of whether an exception to the exemption applies is the ultimate question. Does
Sure.
the exemption apply?
I don't think it's fair to refer to it as an exception to the exemption. It is exempt. I mean, to call it an exception to the exemption, you have to read the word unless, take the and out of the statute and supplant it with the word unless. But even with that being the case, we think that the grant of rulemaking authority at the bottom of the statute does it, 381.0031 sub 8. If you think about it, the practical reality is if the department didn't have a rule, what is the department supposed to do? I think that, the statute was created before, this rulemaking authority existed, right? Because the statute's been in force since the 50s, so before the APA. But, in the late 90s and the early 2000s, when the legislature started imposing all of these rules on on agencies about you can't have non-rule policy, what is the agency supposed to do in that situation, right? They have the statute which tells them all this confidential and exempt information can be released, and you need to release it when you believe there's a public health necessity. So if the agency didn't have a rule, I probably could be challenged that way by exercising some kind of non-rule policy. So I think that's why they did what they did. But we do think that sub 8 of that statute provides sufficient rulemaking authority to the agency.
Thank you.
If I see him, I'll reserve the rest of my time. Thank you.
Thank you.
Good morning.
Good morning.
Andrea Mogensen on behalf of respondents and respondent interveners today. The discussion about this petition begins with really a two-part analysis, whether this court should exercise certiorari jurisdiction, and if so, what the decision would be on the merits. And I'd like to begin by talking a little bit about the threshold questions about whether the jurisdiction should be exercised, and we think resoundingly it should not. It's important to remember that we're here about a discovery dispute, and it has to be shown first that there's irreparable injury. And it was discussed a little bit already this morning. I think that the petitioners are in a very difficult position in showing irreparable injury because what we're really talking about are the normal burdens of defending a case. And this court has held repeatedly, but last year and the year before in Ants versus the Attorney General's office and also in DeSantis versus the Florida Educational Association, that the expense and time of defending yourself is not irreparable injury. And, the deposition that's been requested, frankly, was suggested by the petitioners that we take. A corporate deposition is intended to inform the trial court how they're going to rule on the Apex doctrine.
So, counsel, the cases that you provided, and it is a general proposition that the time and expense of litigation alone does not necessarily constitute irreparable harm, but petitioners have cited cases from this court where we have said that the taking of a deposition that's inappropriate is kind of amounts to cat out of the bag because you can't undo the taking of a deposition. Are you able to distinguish those cases? I think one was in a workers' comp context.
Noticeably, the cases that state that, the relevance issue is sort of agreed upon. In order for petitioners to advance that argument successfully, it's sort of a cart before the horse problem, because the respondents say, this is not relevant because we interpret the exemption this way with this rule and with the exhaustion of administrative remedies, and here's our affirmative defenses. And because our affirmative defenses are correct, your position, which is that the statute's what applies, that they need to make a factual showing that is not in the interest of public health in order to assert the exemption. That's the respondent's position below as the plaintiff. That your position deserves no factual discovery because we're correct. So really what they're asking this court to do is make a decision on the merits that have not been ruled on by the trial court yet in order to deny discovery. The adversarial process obviously works differently than that. Each party is allowed to discover facts, make their presentation of their facts, and the trial court makes a decision on the merits, and at that point this court can review the trial court's decision on the merits, which really leads into the second threshold question. Is this something that cannot be remedied on direct appeal? And clearly it can. While the court is correct, you can't undo a deposition. This deposition was first of all suggested by the petitioners here in order to inform the court on the decision on the Apex Doctrine. Petitioner correctly states this morning that the experts on what's in the public health are the people in the Department of Health, and that's who we seek to depose. Whoever they designate as the person with the most knowledge in the agency to answer the questions that can bind the agency in order to present our factual position to the trial court. And to make a decision that our defenses are correct on the merits, ergo you don't get discovery, is not how this has really ever worked. So that's my response to that, and it also would suggest that the court declined to exercise jurisdiction in this case because we're not talking about, noticeably the cases about irreparable injury usually involve delving into a third party's financial record, something that's sensitive, or making copies that will cost millions of dollars for 450 attorneys and big expenses. We're talking in this case about a very narrowly focused inquiry into the statutory exemption that is being asserted by the defendants below, the petitioners above. So it's not outside the scope of what's relevant. The legislature has determined what's relevant by writing the exemption that the petitioner here relies on. So it's not going into areas that are outside the realm of inquiry. Indeed, it's precisely what's stated as the statutory exemption that's been asserted. Secondly,
the separation of powers concerns that they raise, that's something that just gets cleaned up or dealt with sometime in the case, but it's not a...
I think that the trial court has not ruled on that issue. Indeed, the trial judge specifically stated in the order that's the subject of this petition that ruling would be reserved on those arguments, on the exhaustion of administrative remedies, on the separation of power, on things of that nature, because those are the defenses that will be put forth when we have our evidentiary hearing. 119 contemplates an evidentiary hearing, and that a trial court makes a determination on the merits of the case after an evidentiary hearing, indeed an accelerated evidentiary hearing. And in order to get to that evidentiary hearing, we're entitled to engage in some discovery. I think it's a difficult position to say that there's a relevance problem, an unduly burdensome problem, when it was the petitioners who suggested that a corporate representative deposition be taken in order to sort out their Apex challenge. How are we to respond to that if, frankly, it's kind of a quandary, because we did take the Chief of Staff's deposition, which is part of the record here, and the Chief of Staff said that the Surgeon General independently made the determination without assistance, and then the Surgeon General filed an affidavit in support of their Apex challenge claiming to have no knowledge, no personal or individualized knowledge. So, from a discovery point of view, we're just saying, hey, designate who knows. We'll take a limited deposition. I don't imagine it would be a whole day because there's only 12 to 16 topics that are really shades of gray. How did you determine that this was not in the public health? It's basically the sole question.
There's a whole lot of, this involves 5 weeks of daily data. Am I correct, July and August 2021, 67 counties. I mean, there's a whole lot of, it seems to me in reading the exemption that each bit of information has to get run through this process of whether it can be released, notwithstanding its protection or not. So with 5 weeks, 35 days of data, 67 counties, and I don't know, 100 data bits on each county or whatnot. I mean, this may not be very simple, right? I mean, this is tens of thousands of bits of, okay, is this releasable? Okay, is this releasable?
Well, I don't know that the decision was made that way because it's really a single question. Is it in the interest of the public health to release any data, whether it's a day, 2 days, a week, a month? I mean, there was a point in time where the data was being released on a dashboard, and then a point in time where they said it's not in the public health and will no longer be released at all. So to me, it seems like a single decision that henceforth, so whether my clients had requested a day or a week or a month, one county, one city, aggregate data, what have you, the decision that it was not releasable is really a single decision. It would appear from
So if it's necessary in Miami-Dade for public health, then it also is necessary in Lake County or Leon County.
Right, if it's either necessary for public health to release contagious disease data or not. So it is true. It's same for Lee County, Sarasota County, Leon County. I do think that there's a question that needs to be answered with regard to, the petitioner made a remark and argument, this really shouldn't be a public records case. And I find that very difficult because it's a public records request that was denied. So it absolutely should be a public records case. It is a public records case. And 119 directs that there be an accelerated hearing in circuit court. And I don't know how they can reconcile their position that there should be exhaustion of administrative remedies when the legislature clearly dictated in 119.011 that not only is it circuit court jurisdiction, it's immediate circuit court jurisdiction with precedence over all other cases. And putting plaintiffs in a position where they must exhaust administrative remedies flies in the face of an accelerated hearing in a public interest of the highest order. And so I think that that's where the answer lies to their question on the merits, which I think is frankly premature, as I argued earlier. And I think the Silver Express Company that we cited on page 45 of our response speaks directly to that issue. And what that says, that was a determination where the 3rd District was called on to decide whether Silver Express was precluded from bringing the Sunshine Law action in circuit court because it had an administrative remedy available. And what the 3rd District said was this, that a citizen may have an available administrative remedy does not preclude him from pursuing the public statutory remedy on behalf of the public interest in an open government. The two are unrelated remedies, one for the individual's own private interests, the other for the goal of public vindication. And they go on to say, the legislative intent behind section 286.011, which is the Sunshine Law, would be frustrated if the public's champions are to be relegated to administrative proceedings of whatever nature, where the legislature is specifically provided in the controlling statute for jurisdiction of the circuit courts. And that's the exact issue that really is being advanced by the petitioners here. And that's the argument I just made. It doesn't reconcile.
How about the Society of Newspapers case that they're using that seems to kick things into the administrative question?
Well, I think the difference in Silver Express wasn't advanced in that case because it is true when you bring an action under the Sunshine Law, either public records or open government meetings, you are vindicating a public interest, which is a separate and distinct piece. And of course, my clients have an individual interest in the records, but I think that that's what sort of knocks that out of that particular consideration. In that case, in Florida Society of Newspapers, there was already an ongoing administrative hearing going on. And so when you're already in the administrative arena, the discovery in the administrative process, I mean, it was a different animal. Here, we're exercising a right to vindicate a public interest that clearly dictates that we're in circuit court. So I don't think that's really applicable authority. The other thing I wanted to make sure that we brought to the court's attention, I think the plaintiff's position, the petitioner's position with regard to the APA and the administrative exhaustion is controlled by the APA itself. In 120.73, it specifically says, nothing in this chapter shall be construed to repeal any provision of the Florida statutes which grants the right to a proceeding in the circuit court in lieu of an administrative hearing, or to divest circuit courts of jurisdiction to render declaratory judgments under Chapter 86. And as I just mentioned, 119.011 specifically puts us in circuit court, vests jurisdiction in circuit court. Petitioners concede it's not a jurisdictional issue. So in looking at the APA, you have to look at it as a whole, and it specifically says within the Act that it's not intended to divest the trial court in this case of jurisdiction over this case because there's a legislative grant of jurisdiction. It's an alternate remedy. It's a public vindication issue, it's an individual request for records issue, and arguably right to records issue unless exempt. So,
Do you agree that this is confidential and exempt information that can be released as opposed to it's not confidential and exempt, or does that, any of that matter?
well, if you think about the exemption itself, 381.0031, it says that it's confidential and exempt and is to be made public only when necessary to the public health. So the legislature obviously contemplated release of this information under specific conditions when necessary to the public health. So that's what the determination is. It's confidential and exempt unless. So it's an exemption with an exception. And that's what the burden of proof is for the petitioners when we get back to trial court and have an evidentiary hearing to show that it's not in that category of unless when necessary to public health.
Could you please address petitioner's argument about paragraph 8 in 381.0031 about how that gives them rulemaking authority over public records?
I think a plain reading of that subsection makes the conclusion that that's rulemaking authority for limiting public records access absurd, to be honest. Because what it says is that the department may adopt rules related to reporting diseases of significance to public health. And it doesn't say anything about public access to information gathered. It's a section about rules related to reporting for the reporters, for the clinics, for the doctors, for the hospitals who are reporting. And they have made such rules. And it goes on to say that their rules must specify the information to be reported, who's required to report, method and time period for reporting, requirements for enforcement, and required follow-up. It doesn't say anything about giving authority to the department to contract a public records exemption. And frankly, they're contracting it to nothing. Because if they say, we're the sole determiner of what's in the public health, and it's not, that's an absolutionist thing. You know, that's actually a separations of powers problem, because the legislature said, when it's necessary for the public health, it's to be released. And the department is usurping that by saying, we'll be the arbitrator of what the exemption is here. So the separation of powers problem really...
Your time has expired, if you'll briefly wrap up.
Okay. The separation of powers issue is kind of misleading because really it's the legislature, as was noted by the court here, that has the sole authority to determine what public records will be exempt. The Public Records Act is to be construed in favor of openness. It's a constitutional right of the people to get information from the government because the government is the people, the government information is owned by the people, but the legislature can determine when things are exempt from disclosure. For an agency, a party, to be able to dictate over what the legislator has said, what that will be, or to expand it or contract it, is not permitted under the separation of powers doctrine. So we would argue that the separation of powers doctrine actually works against petitioner rather than for them.
Okay, thank you, counsel.
Thank you.
Madam Clerk, if you'd please extend petitioner's response time, I believe, by a minute.
Thank you. There are a few things I'd like to clarify, but I'd like to start by highlighting what I thought the most important part of that argument was, which I saw as kind of an implicit concession that the only way to get to the plaintiff's view of the statute is to read words out of it and to add words into it. And what it says is information submitted in these reports, which is the information we're talking about, is confidential, is exempt from the provisions of 119, and is to be made public only when necessary to public health. That "and" there means all three of those things are always true. All of this information is confidential. All of this information is exempt from inspection under Chapter 119. And notwithstanding the fact that it is all confidential and exempt, it is nonetheless to be made public, but only when necessary to public health. So I just don't think it's reasonable to take the position that this is an affirmative defense that needs to be established factually at the trial court. It would require looking and ignoring the plain language of the statute. A couple of other points that the plaintiff made that I think warrant some clarification. The suggestion was made, and we did cover this somewhat in our brief, that first of all, that we made an apex objection, of course, to the Surgeon General himself being called to testify. We did offer the Chief of Staff, which is a pretty high-ranking agency official, to testify instead. And this is in the record, of course, her deposition transcript is in the record. You can see it's not that she said that the decision was made by the Surgeon General and the Surgeon General alone. What she said was, this is a collaborative decision that was ultimately made under the ultimate authority of the Surgeon General. So just a point of clarification there, and you can go back and look at it if you need to. In terms of whether we invited this deposition, yes, there was a hearing to address our apex doctrine argument to their request to take the Surgeon General's deposition. The issue was to address a separate concern, and that transcript is in the record too. So the separate concern was the trial court was reasonably concerned that we would take the position that without the Surgeon General there, nobody would be binding the department, and so it would be a bit of a continuous loop. We said, to the extent you want somebody to be available to bind the department, take a corporate rep deposition. We never suggested, and we didn't realize at the hearing, we knew that necessary to public health was potentially an issue for them, but we didn't realize it was literally the whole case. What this was really all about for them was this public health determination. And you certainly can't construe anything in our request, in our suggestion that they do a corporate rep deposition, that we were just saying that whatever topics, no matter what, we were waiving any objections on the basis of relevance, on the basis of overbreadth, on the basis of separation of powers. It's just not reasonable to see. I'm almost out of time. One of the other points that Ms. Mogensen raised was 120.2073, that statute. She says that provision takes it out of the realm of the Florida Society of Newspaper Editors case, to the extent you even have to get there. I just wanted to observe that statute was specifically cited in the case. I see I'm out of time. Thank you.
Thank you to both counsel for your arguments today. The court is now adjourned.
All rise.
this?
I flew in.
Wow. Where do you live? I thought,
Wisconsin.
oh, it's,
I stopped doing trial court work here, but then the pandemic hit and delayed a bunch of cases, and I took a select few and figured I'd come down to work.
where do you live in Wisconsin?
Madison.
Okay.
That's the only place I live in Wisconsin. Well, Milwaukee's pretty cool too. But
I have a friend who, former AG lawyer friend of mine, who's planning to like locate up like on Wisconsin near Duluth, kind of like the southern edge of Lake Superior. So I have no idea where.
that's cool.
I'm
I
sure
mean,
it
it's
is.
pretty amazing. That's about 3 to 4 hours from where I live, depending on where in that region.
Mhm.
And those 3 to 4 hours give you like 3 weeks
I'll get
less
Leslie
rain
to check.
and 3 weeks.
Make sure you get
of
the permissions on
snow.
this
It's
one.
ridiculous. How
I bet
different
that's what it is.
You're right at
Is it
that edge
just-
of those temperate zones.
Yeah.
And southern Wisconsin is remarkably different. I mean,
So
when
it allows you to
I have
come
relatives who
through
live up in that area, and we
back
drive up there for Christmas,
Sure.
and you just lose it in the car on the
Okay.
way up there because you could feel it coming through the window.
Yeah, it's gonna be just a store, is what it is. So we'll take care of that. Well, I mean, when it first didn't open, I was like, we tried it either too quick or too late. And then when you hit it again, I'm like, and so I was ready to say, I'll get it taken care of. It'll be clear before we do it again. All right.
In Florida, it's really hot.
Okay. Yep. It'll be fixed by then.
Once you're down to the bare minimum, including your
Yeah, I'm getting around good. Neat. I had a little bit of a problem for about a week where it felt like it was locking up, but I don't know what it was. Oh yeah, that's right. Is
Refer this to some, it starts with O, overstate.
that one doesn't ring a bell. Is he going to do a full knee replacement or a partial, or you don't know?
It's, he had an accident like 15 years ago.
Okay.
And they did some,
Right.
but things haven't improved since.
Right. Well, David Bellamy did mine. He's with Tallahassee Orthopedic.
Okay, it's the same,
Okay.
okay.
Yeah. He's good. I highly recommend him. In fact, he's going to do my other knee in December. So,
Didn't you already have?
so the left